नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Did I discuss Keshavanand and Bharti from the case material in this class, or was it the other section? Can anyone remind me?
No, ma'am, we discussed Golaknath case.
Okay, fine. So, what we'll do today is we will discuss Keshavanand and Bharti as well as I think if we discuss Golaknath, I must have discussed Keshavanand and Bharti. Anyway, we will just discuss Keshavanand and Bharti, and then also IR Coelho judgment, which is another basic structure, case on basic structure, which is a part of your unit 1. Now, just to briefly summarize what we discussed last time. So, in the last two classes, so what we have discussed is that basic structure doctrine and the reason why basic structure doctrine came into being. And we also discussed how Golaknath judgment interpreted basic structure doctrine, right? So if you remember, basic structure doctrine was interpreted in Golaknath judgment, and was actually basic structure doctrine was not brought in Golaknath judgment. Rather, what was said in Golaknath judgment that there are certain limitations on the power of the parliament to amend the constitution. Now, how were those limitations read as a part of the constitution? What Golaknath judgment said was that constitutional amendments are law under Article 13 of the constitution. Now, if you look at Article 13 and specifically Article 13(3)(a) of the constitution, it defines law. And it says that law includes, and I hope you have a BEAR Act in front of you, and if you could just open it to Article 13, Clause 3, Subclause A. What does Article 13(3)(a) say? It defines law, and it mentions that in this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India the force of law. So that is how law has been defined under Article 13(3)(a). Now, what Golaknath judgment did was, if you remember, I told you in the very beginning when we were discussing a brief discussion on Part 3 of the Constitution, that if you have to prove that there are two ways of challenging something for violating fundamental rights. The first is that you will have to prove that the violating entity is a state, okay? Because primarily, Part 3 of the Constitution is vertically arranged. That means that not all, I am not saying all provisions of Part 3 of the Constitution. So, that is something those are the two important provisions that you need to understand before you even go into the question of whether there is any violation of fundamental right or not. First, that you will have to prove that the violating entity is the state. And in case you are arguing that a legislative enactment violates fundamental right, then you will have to prove that that specific law is a law under Article 13(3)(a). Now, you already have studied about one form of law which has not been considered to be a part of Article 13(3)(a). Any idea which law is not a part of Article 13(3)(a)? And we have already studied it as a full-fledged course.
Ma'am, law in 9th schedule.
Okay, not exactly, and this is something that we will come to when we are discussing IR Coelho. Yes, Sagar, personal laws and amendments. So, I'm not going to say amendments right now because we are still having a discussion on amendments. Yes, very correctly said, personal laws. If you remember your family law lectures, there must have been a discussion on whether why are personal laws not challenged for violating fundamental right, because there are so many aspects of fundamental personal laws which are on the face of it discriminatory. And you must have studied those aspects. For example, if you look at Hindu Succession Act, the manner in which property is distributed vis-a-vis married woman and a male. Now, married female's property, primarily it goes to the husband's family. And only when even the agnates and cognates of the husband's family are not there would it revert to the woman's parents. On the other hand, that is not the case with the succession of property when it comes to a male. And even in so there are several instances of discriminatory laws when it comes to personal laws. But why are personal laws not challenged for violating fundamental rights? Not that they're not challenged, but why have they not been declared unconstitutional? Because if you remember Shaira Bano judgment, and I'm sure you must have read Shaira Bano judgment in your family law, there is something called Narasu Appamali case wherein it was said that personal law is not a law under Article 13. Now I'm not going into the details of that. If you want to read further on how Narasu Appamali case unfolded and what is this interlink between Article 13(3)(a) and personal law, maybe you can look at 3 pieces of literature or judgments. One is Narasu Appamali, obviously, which is a Bombay High Court decision. The second is Justice Nariman's opinion in Shaira Bano judgment, which is a triple talaq judgment. And the third is Justice Chandrachud's opinion in Indian Young Lawyer Association case, which is the Sabrimala Entry Temple case. So these are the 3 opinions. If you read, you will have a fair idea of how personal laws are placed under Article 13(3)(a). But yes, Sagar, so I'm not going into the detail of personal laws. Yes, but personal laws have not been categorically considered to be a part of Article 13(3)(a). Now, it is not that easy because obviously certain changes have happened, specifically when you read Shaira Bano judgment and Nariman's opinion. But for the time being, you can understand more or less personal laws are not considered to be a part of Article 13(3)(a), and therefore they are not challenged they cannot be per se challenged for violating fundamental rights. Now, the second is amendments, yes. But before we come to amendments, let's first understand Golaknath judgment. What Golaknath judgment said was that amendments are law under Article 13(3)(a). Constitutional amendments are law under Article 13(3)(a). And because constitutional amendments are law under Article 13(3)(a), anything that is a law under Article 13(3)(a), what can be done? It can be challenged for violating fundamental rights. So because constitutional amendments are law under Article 13(3)(a), they can be challenged for violating fundamental rights. Now the reason why Golaknath judgment said is, and I think we discussed it in the last lecture, was because Golaknath judgment argued or held in its majority decision that the power to amend the constitution is found in the same provision where you find ordinary legislative power of the parliament. That is Article 245 to 248. So the ordinary legislative power of the parliament, what is ordinary legislative power? And we already drew a distinction between ordinary legislative power and constituent power. Ordinary legislative power is the power of the parliament to bring about simple enactment, which does not involve amendment of the constitution under Article 368. Now the ordinary legislative power of the parliament and the constituent power of the parliament both are vested in the parliament by virtue of the same provisions, that is Article 245, 246, 247 and 248. And because both of them, it is the same provision that vest on the parliament both the ordinary legislative power and the constituent power, therefore we cannot put them into any sort of hierarchy such that ordinary legislative power is subject to being challenged for violating fundamental rights, but an exercise of constituent power cannot be challenged for violating fundamental rights. I hope you understood I.C. Golaknath's rationale as to why amendments were considered to be law under Article 13(3)(a). If you have not understood, just let me know. Because the reason being that it was held by the court that the parliament derives the power to exercise its ordinary legislative power as well as to exercise its constituent power from the same provisions of the constitution, and that is Article 245 to 248. The power to exercise constituent power has not been vested on the parliament under Article 368 of the constitution. That is one of the reasons, and therefore, as a consequence, what Golaknath judgment said was that therefore Article 13(3)(a) in the term law includes constitutional amendment. Now, as soon as you say that the term law includes constitutional amendment, you automatically come to the conclusion that these amendments can be challenged for violating fundamental rights, because anything that is a part of Article 13(3)(a) can be challenged for violating fundamental rights. And that is how I.C. Golaknath judgment said that because amendments are law under Article 13(3)(a), it can be challenged for violating fundamental rights. Now, the reason why such limitation was read on constitutional amendment was because Golaknath judgment was conceptually in favor of controlled power of amendment of the constitution, such that the power of the parliament to amend the constitution is not unlimited, but it is a limited power. It is subject to certain substantive restrictions as well, not just the procedural restrictions that we discussed under Article 368, that is special majority or special majority plus ratification, but also substantive restriction in the form of Part 3 of the Constitution. Now, what happened in Keshwanand Bharti case, subsequent to Gorakhnath judgment, when we come to Keshwanand Bharti case, Keshwanand Bharti case more, because, okay, before Keshwanand Bharti case, there was 24th Constitutional Amendment, okay? And we have discussed that if you look at 24th Constitutional Amendment and if you look at the present Article 368, you will find it very interesting, because almost each and every argument that was made in Gorakhnath judgment for restricting the power of the Parliament to amend the Constitution was overturned one by one by 24th Constitutional Amendment. So 24th Constitutional Amendment basically had the effect of basically making IC Gorakhnath judgment redundant, such that the Gorakhnath judgment was completely overturned and each and every point of law that was laid down in Gorakhnath judgment was reversed by the 24th Constitutional Amendment. And I will just give you one example. If you look at the marginal note, okay, of Article 368, just please open your barracks to Article 368. I'm not going to give you a point-by-point discussion, but just take a look at the marginal note. It says, power of the Parliament to amend the Constitution and procedure thereof. Now, and if you look at the footnote 1, what you will find is, substituted by 24th Constitutional Amendment 1971 for procedure for amendment of the Constitution. Now, before the 24th Constitutional Amendment, this note only read procedure to amend the Constitution. But because Gorakhnath judgment said that the power to amend the Constitution is not vested in the Parliament under Article 368, rather it is vested under Article 245 to 248, therefore 24th Constitution Amendment, in order to clarify the position and reverse the holding of IC Gorakhnath judgment, made an amendment to Article 368, where it categorically held that Article 368 is not just about the procedure of amendment, but rather it also vests in the Parliament the power to amend the Constitution. And similarly, there are several other parts of this Article 368 which had been revised by 24th Constitutional Amendment, only with the objective of reversing what was said in Gorakhnath judgment. When it comes to Keshwanand Bharti, 24, 27, 29 Constitutional Amendment as well as Kerala Land Reform Act was challenged. Now, Keshwanand Bharti case agreed with Gorakhnath case on just one basic point, but apart from that, Keshwanand Bharti also overruled Gorakhnath judgment. Now, the point that it agreed on with Gorakhnath judgment was that yes, the power of the Parliament to amend the Constitution is not unlimited; it is subjected to certain restrictions and certain substantive restrictions. But the content of this restriction was something that Keshwanand Bharti disagreed with respect to Gorakhnath judgment. In Gorakhnath judgment, the content of restriction on the power of the Parliament to amend the Constitution was fundamental rights, right? Because Gorakhnath judgment said that amendments are law under Article 13(3)(a) and therefore will be subject and amenable to fundamental right challenge. But that was not something that was held in Keshwanand Bharti. Keshwanand Bharti said, and as Sagar pointed out, that amendments are not law under Article 13(3)(a) of the Constitution, such that the Parliament, in exercise of its constituent power, can even amend Part 3 of the Constitution. But that does not mean that Part 3 of the Constitution is not subject to certain limitation. It is subject to certain limitation, but those limitation is in the form of basic structure doctrine, which is not necessarily entire Part 3 of the Constitution. It is in the form of basic structure doctrine, right? And that is how Keshwanand Bharti came up with basic structure doctrine. Now, we have already discussed how basic structure doctrine was defined by different judges in Keshwanand Bharti in different manners. I'm not going to go into that. Now we will proceed further beyond Keshwanand Bharti, and we will come to IR Coelho judgment. But before we come to IR Coelho judgment, we need to follow the historical development that happened post Keshwanand Bharti, and how how Keshwanand Bharti was elaborated, how the basic structure doctrine was elaborated post Keshwanand Bharti. Before that, I will just respond to Runchun's comment. Can notifications under the Disaster Management Act currently be challenged in the court? Yes, Runchun. All executive and legislative actions can be challenged before the court.
Ma'am, so they will be considered as law under Article 13 that we just discussed?
Yeah. Yes, definitely. So you just open Article 13(3) and see what does it say. Law includes any ordinance, order, bylaw, rule, regulation, notification. Of law is rather exhaustive because it says, what does it say? Ordinance, order, bylaw, rule, regulation, notification, custom or usage, having in the territory of India the force of law. Okay.
So this is different from what's required in the legality test. Like that's something different that we require.
No, what we require in the what we say that there needs to be a valid law, the reason, you have to see the reason why that legality test is invoked. It is invoked because it is saying that you can only, there has to be a valid law before you restrict freedom of speech and expression. Or not freedom of speech, any fundamental rights, right? So there has to be a valid law before you restrict any of the fundamental rights. So yes, there will be an overlap between how law is understood there and between how law is understood under Article 13(3)(a). But the ambit of law when we come to legality test is much wider, because in that case even constitutional amendments can be considered to be a law. But with respect to Article 13(3)(a), constitutional amendment is not considered a law. So when you are invoking proportionality test, we take a much wider definition of law, right? Instead of law being just confined to what is mentioned under Article 13(3)(a). That is how maybe you can understood. The only purpose, you have to look at Article 13(3)(a) as to what is the purpose behind Article 13(3)(a). Only those laws which fall under Article 13(3)(a) can be challenged for violating fundamental rights. Okay, but there can be law like constitutional amendment is also a law. But the constitutional amendment cannot be challenged for violating fundamental rights per se, but it can definitely be challenged for violating basic structure. And some of the fundamental rights are a part of basic structure, so indirectly constitutional amendments can be challenged for violating some of the fundamental rights at least. So, but just in order with respect to your question, the reason why law is defined under Article 13(3)(a) is to give a definition of law which can be challenged for violating fundamental rights, but there can be law beyond the definition of Article 13(3)(a). Like Jaga just mentioned, personal laws and amendments, they are also laws, but not laws under Article 13(3)(a).
All right, ma'am, understood.
So, yes, there is a question. Which provisions impart authorized SC to provide basic structure? The power of judicial review, Sagar. So you have the power of judicial review which has been conferred on the judiciary. Article 13 itself confers the power of judicial review. Article 32 confers the power of judicial review. So the power of judicial review allows the judiciary to come up with doctrines in order to review government state action. So there are several powers spread across the Constitution. The provisions that confer jurisdiction on the Supreme Court, Article 32, Article 13, all these provisions are authorizing Supreme Court to come up with concepts and doctrines and exercise their power of judicial review. So there is no one specific provision which will say that judiciary has the power to give basic structure doctrine, but it all comes within the fold of judicial review. Okay, so now let's come. What we're supposed to discuss was post Keshwanand Bharti. Now, Vikas, are you trying to say something? Okay. Vikas, are you trying to say something? Or okay. Fine. Now, in the initial years, the basic structure doctrine was obviously more or less confined to land reform. So if you look at, or at least the evolution of basic structure, something that led to the evolution of basic structure doctrine was confined to land reform. So if you look at Shankari Prasad, Sajjan Singh, Golaknath, KESHWANAND, BHARTI, all of them more or less dealing with land reforms. Now, the first case that sort of expanded basic structure doctrine to those cases that does not deal with land reform is Indira Nehru Gandhi versus Raj Narayan. Now, you may have read this judgment or at least been aware of this judgment. This judgment This was the case wherein Indira Gandhi's election was challenged before the Supreme Court, and whether and 37th Constitution Amendment was also enacted by Indira Gandhi, wherein it was said that that the election of the Prime Minister and the Speaker of the Lok Sabha are not going to be challenged before any court of law, more or less taking away the power of judicial review vis-a-vis the challenge, vis-a-vis when it comes to challenging the election of few posts, election to few posts. Now, Indira Nehru Gandhi, and I'm not going to go into the detail of this judgment, but you only need to understand that Indira Nehru Gandhi versus Raj Narayan was the first case wherein the basic structure doctrine was applied to a case which did not deal with land reforms. And it was held in this judgment that separation of power is the basic structure of the Constitution, such that, and judicial review is the basic structure of the Constitution, and no law can be made to violate the separation of power or impinge on judicial review. So that was the first case, and it was an important development in basic structure doctrine because it helped expand the ambit of basic structure such that over a period of time, eventually basic structure expanded to a very large extent. Now, let us come to I.R. Coelho judgment, and I will just, and it's not a very long judgment, I.R. Coelho, and if you please go through this judgment, because at least but just by reading this judgment, not that it is sufficient to understand basic structure, but at least you will get a very fair idea of what basic structure doctrine is about. Now, in I.R. Coelho judgment, the question before the courts was whether the laws which have been added to the 9th schedule, and this is something that one of you said, that laws in 9th schedule are not laws under Article 13(3)(a). And I.R. Coelho judgment would maybe respond to that question or that comment of yours. Now, in I.R. Coelho judgment, what we were discussing was whether the laws which have been added to 9th schedule can be subjected to basic structure or not. Now, before we understand what is the 9th schedule, let us just have a look at Article 13(1)(b) of the Constitution. So, again, I am hoping all of you have a Bare Act before you. So, please open Article 31(b) of the Constitution. Now, what does 31(b) say? It says that, without prejudice to the generality of the provisions contained in Article 31(a), none of the acts and regulations specified in the 9th schedule, nor any of the provisions thereof shall be deemed to be void or ever to have become void, on the ground that such act, regulation or provision is inconsistent with, or takes away, or abridges any of the rights conferred by any provisions of this part, and notwithstanding any judgment, decree or court order of any court or tribunal to the contrary, each of the said acts and regulations shall, subject to the power of any competent legislature to repeal or amend it, continue in force, right? So what is Article 31(b) saying? That any law which has been inserted in the 9th schedule is completely immune from being challenged for violating fundamental rights. Okay? That is the impact of 9th schedule. So any law that has been put under 9th schedule is immune from being challenged for violating fundamental rights. So as far as one of you said that laws in 9th schedule may not be considered to be laws, if you go by the strict interpretation, or if you look just at Article 31(b) and not at what I.R. Coelho judgment said, then yes, that is true. But that is not the case now. And that is something that will be discussed in I.R. Coelho judgment. So what I.R. Coelho judgment is what is the issue before the court? That whether the laws in 9th schedule can be immunized from being challenged on the grounds of violating fundamental right. And specifically those laws which were added to 9th schedule after 24th April 1973. Now, what is the relevance of 24th April 1973? Because on this day, KESHWANAND BHARTI judgment was pronounced and the basic structure doctrine was promulgated or was developed. Now, that means that the basic structure doctrine, at least after the judgments, after the KESHWANAND BHARTI judgment, is going to govern how you are going to determine legitimacy of any law. Now, what was done? Now, this is the main question for the court, and the court went into a detailed analysis of the entire basic structure doctrine and the development itself. However, the main question being that whether it is possible for the Parliament to immunize legislations under Article 31B by inserting them into the 9th schedule from fundamental rights completely. Can judicial review be circumvented to the extent that 9th schedule laws inserted in 9th schedule cannot be called into question before the laws? Now, if I say fundamental right, it also includes Article 32, right? Because Article 32 is also part of the Constitution. And what does Article 31B say? That no provision of this of any of this part can be said to be inconsistent with the laws if they are inserted in the 9th schedule. Now, if you look at the initial laws which were inserted in the 9th schedule, most of them were land reform laws. But subsequently what started happening was a lot of non-land reform laws also started being put within 9th schedule of the Constitution. And therefore, the dilemma before the court that was there any point of having a basic structure doctrine itself? Because if the Parliament did not want a specific law to be challenged for violating basic structure of fundamental rights, it could very well put that specific law under the 9th schedule and immunize it from judicial review altogether. Now, as we discussed, judicial review has been considered to be a part of basic structure. So can the Parliament, in exercise of its power under Article 31B, prevent judicial review of laws under the 9th schedule? Especially in the situation where judicial review has been considered to be a part of basic structure of the Constitution. For example, in the Nehru-Gandhi versus Rajnaran, Minerva bill case, all these judgments have categorically again and again repeated that basic structure, judicial review is a part of basic structure. Now, what the court held in this case was that what is the basic structure of the Constitution? Now, and for that I will take you to an interesting discussion. If you remember when we discussed KESHWANAND, I told you that it was a 7-6 decision, majority, right? 7 judges in favor of basic structure doctrine and 6 judges ruling in favor of Parliament having unlimited power to amend the Constitution. Now, out of those 7 judges who ruled in favor of basic structure doctrine, one of the judges, Justice Khanna, when he was describing the contents of this basic structure, basically said that Article 19(1)(f) is not a part of basic structure. That is, right to property is not a part of basic structure. And this led to a lot of confusion subsequently because Justice Khanna's this statement was interpreted by many as implying that fundamental rights are not a part of basic structure, or Part 3 of the Constitution is not a part of basic structure. Now, however, Justice Khanna clarified his position in the Nehru-Gandhi versus Rajnaran and said that I never said that fundamental rights cannot be a part of basic structure. Rather, what I said that not all fundamental Part 3 automatically in totality does not become a part of a basic structure, but obviously there are certain rights under Part 3 which can be considered to be a part of basic structure. And right of property is not one of those rights which is a part of basic structure, but there can be other rights which are a part of basic structure. So that position was clarified by Justice Khanna in the Nehru-Gandhi versus Rajnaran. Now, what happened subsequently was obviously there was a lot of discussion as to whether fundamental rights can be considered to be a part of basic structure or not considered to be a part of basic structure. Then we come to Maneka Gandhi judgment, wherein it was held that at least Article 14, 19 and 21, the trinity of these articles is something which is a part of basic structure. Okay? So, while you can amend the text of Article 14, 19 and 21, you cannot take away the essence of Article 14, 19 and 21. So, at least that essence of Article 14, 19 and 21 is a part of basic structure. Now, that is the essence of rights test. That you cannot take the essence of certain fundamental rights, so you can definitely amend the text of Part 3 of the Constitution. Now, having said so, what Ayar Coelho judgment is basically has to look into is whether what is happening through 31B and 9 schedule. What is happening is that fundamental rights become completely inapplicable on Part 3 of the Constitution, and the judiciary fundamental rights become completely inapplicable on laws inserted in the 9th schedule, and the judiciary can no longer review 9th schedule laws on the ground of whether it violates fundamental right or not. Now, what the court said in Ayar Coelho judgment was, and this is something which is not permissible. And why is it not permissible? Because there is, and please listen to this very carefully. There is something called essence of rights test, and there is something called rights test. Okay. Now, we already know that while the text of fundamental rights can be amended, the essence of those texts, for example, cannot be amended. So tomorrow you cannot insert another 510 in restrictions under Article 19 clause 2 of the Constitution, because example, let's say, and I gave an example of how criticism of the government cannot be perhaps a restriction of freedom of speech and expression under Article 19(1)(a), because that would take away the essence of freedom of speech and expression. So while amendments can be made to the text of the Constitution, you cannot make an amendment that takes away the essence of that specific right itself. Now, however, there is something called the rights test, which was put forth in Iyer Coelho judgment, because what was happening in this case, that we are not just talking about essence of right being taken away, because fundamental rights were not being amended per se, but rather were being made inapplicable on 9 schedule laws. So what the court says that when a state action, Parliament passes a law such that it completely removes the applicability of Part 3 of the Constitution on certain laws, what you are violating is not just the essence of the right, but the right in itself. It amounts to basically completely obliterating the Equality Code, the Liberty Code, etc. So with respect to 9 schedule laws, it is as if Article 14 does not even exist. Article 19 does not even exist. So that is something which is in itself problematic, because what you are impinging on is the rights itself. And that is something which cannot be allowed. And that's why when we're talking about fundamental rights, or when you're talking about 9 schedule laws, no law can be passed by the Parliament such that it violates the basic structure of the Constitution in any manner. And fundamental rights, at least the essence of fundamental rights, is a part of basic structure of the Constitution. At least Article 32 is definitely a part of basic structure of the Constitution. And when we say Article 32 is a part of basic structure of the Constitution, it automatically implies that fundamental rights, or at least the essence of those fundamental rights, become a part of basic structure of the Constitution, such that no law can escape the applicability of the essence, what lies as an essence of Part 3 of the Constitution. And at least some of the provisions of Part 3, like 14, 19, and 21, have to be applied. That even the rights, the Article 19(1)(a) per se, Article 14, Article 21, those are rights which cannot be removed in any manner or altered in any manner. And that is something which was said in Iyer Coelho judgment. Now, the second thing that was said was that when basic structure, obviously, the idea of basic structure is that Parliament, in exercise of its constituent power, would not amend the Constitution in a manner that violates basic structure. So when the Parliament cannot make a law constitution amendment in violation of basic structure, it also implies that the Parliament cannot allow laws made by the Parliament or the state legislatures to be in violation of basic structure, because there is a kind of hierarchy of norm, right? So if the Constitution cannot violate basic structure, ordinary laws or laws made in exercise of ordinary legislative power also cannot violate basic structure, because ordinary legislative power have to conform to the Constitution, and Constitution has to conform to basic structure. That means that you cannot insert laws in the 9th schedule and immunize them from being challenged on the ground of violating fundamental rights, because at least some of these fundamental rights are part of basic structure. That means that these laws can definitely be challenged for violating fundamental rights. Okay? So, the basic structure doctrine. Now, having said so, what the court said that because Article 32 is a part of basic structure, that means that you cannot immunize laws from being questioned, from being challenged under Article 32. And once a challenge under Article 32 becomes sustainable vis-a-vis 9th schedule of the Constitution, what does it automatically imply? That you can challenge 9th schedule laws also for violating all fundamental rights, right? Because the laws inserted in the 9th schedule are per se not constitutional amendments. They are just, the laws have been inserted because the laws are enacted in exercise of ordinary legislative power. So those laws, not only can you challenge, so what the court is saying is, not only can you challenge a constitutional amendment that inserted a law under 9th schedule, but you can also challenge the laws under 9th schedule for violating basic structure. And the laws under 9th schedule, one, because it immunizes those laws from being challenged under Article 32, Article 32 being a part of basic structure doctrine. That means that Article 32 becomes challenge under Article 32 is something which is allowed with respect to the laws which have been inserted under the 9th schedule. And if a challenge under Article 32 is allowed, it automatically implies that the laws which have been inserted under the 9th schedule can be challenged for violating fundamental rights. But the constitutional amendment which has inserted that specific law in the 9th schedule can only be challenged for violating basic structure doctrine. I hope that is clear, IR Coelho judgment. If not, just let me know. I'll just repeat it again. Any confusion with respect to IR Coelho judgment? No confusion at all. Okay. Fine. So this is what IR Coelho judgment is saying, that it is basically a 9th schedule, and what was held in IR Coelho judgment was that laws which are inserted through a constitutional amendment under 9th schedule, those specific laws can be challenged for violating fundamental rights because Article 32 becomes a part of basic structure. And if Article 32 becomes applicable on those laws, automatically all those specific laws can be challenged for violating fundamental rights. Because an ordinary legislative power itself, a law made exercise of ordinary legislative power obviously cannot go in violation of fundamental rights. Now, from that perspective, 9th schedule laws are no longer immunized from being challenged for violating fundamental rights. And by that logic, 9th schedule laws will also be considered to be laws under Article 33 of the Constitution. Right? So, that is IR Coelho judgment. Was someone trying to say something?
Ma'am, in just one logic, ma'am,
Yes.
what could be the primary reason that the laws, or basically the schedule, when we talk about this basic structure doctrine, so when we say that Article 31B is now open to challenge, what is the
Yes.
primary reason behind it? Why
The reason-
9th schedule? Why 9th schedule is being challenged? Just one logic.
The only logic being, Akash, that you cannot take away the power of judicial review. Judicial review is a basic structure of the Constitution. So, any constitutional provision or amendment that tries to impinge or circumvent or prevent judicial review from happening is a violation of basic structure. What is Article 31B doing? It is saying that laws under 9th schedule cannot be subject to judicial review. That is something that is not allowed. And that is one of the main reasons why 9th schedule laws have now been made amenable to judicial review. Right? Did that answer your question, Akash?
Yes, ma'am. So basically, we need to focus only on judicial review. That's it.
That is one of the main reasons, but not just on judicial review, because basic structure doctrine also has several aspects. If Article 31B was, let's say, and it's not just judicial review, the main, obviously, one of the primary reasons is made judicial review, but Article 31B, for example, also allows violation of other parts of basic structure, like Article 14, 19, and 21, because according to the text of Article 31B, you cannot challenge the law for violating even Article 14, 19, and 21. So those are also important aspects of Article 31, not just judicial. You cannot say that you just need to focus on judicial review, but yes, judicial review is one of the primary reasons why primary aspect of basic structure doctrine on the ground of which Article 31B was subject to judicial review. Obviously, that is one of the primary reasons. But I don't think the argument that we only need to focus on judicial review suffices, because there are different other aspects of basic structure also that has to be taken into consideration. And IR Coelho case did not just rely on judicial review. So it was a primary ground on the reason why 9 schedule laws were brought within the fold of Article 33.
Okay, ma'am. Thank you, ma'am.
Okay. Anyone else? Any question? any question, any conclusion, any comment that you have, anything that you disagree with.
Ma'am, on a very humble note, I would like to disagree with one logic which explained just now. That is why I raised my previous doubt.
Okay.
So when you said that when Parliament cannot make any amendments which violate the basic structure, that is clear, fine. Now, when you say based on the hierarchy of norms, then any legislations made by any ordinary legislations, they cannot also be challenged. But when we talk about this Article 31B, not by being by virtue of so ultimately Article 31B is in effect. That if any ordinary legislation is made by any parliament, so it is not by the virtue of that legislation, but by the virtue of Article 31B. So again, constitutional amendments are in play. So we cannot draw that logic that okay, fine, if you cannot, if amendments cannot be challenged, so we cannot say that okay, 31, so ordinary legislations cannot also be challenged. So basically,
that is not what was being said, Akash. What was being said was that if amendments are challenged for violating basic structure, that automatically implies that ordinary legislative law will also be challenged for violating basic structure. That is the argument which is being made in Iyer Goyal judgment. So you have to understand it. What is a constitutional amendment? Constitutional amendment defines the constitution, right? Now, if you are inserting Article 31B in the constitution, that automatically implies that Article 31B is a part of the constitution. Now, Article 31B, therefore, any constitutional amendment has to comply with what? Basic structure doctrine. Now, if Article 31B has to comply, and any provision of the constitution per se has to comply with basic structure doctrine, what does it mean? So let's first, at the first instance, constitution has to comply with basic structure doctrine, right? On the second instance, as we all know, all ordinary laws or laws made in exercise of ordinary legislative power have to comply with what? Constitution, because you can at any point of time determine the constitutional validity of the constitution. So that means that ordinary legislative power, laws made in exercise of ordinary legislative power, okay, have to comply with what? The constitution. Defined precisely? No. So it is problematic to expect, by law must be precise. It is problematic to expect too much precision in the form of a mathematical formula in law. That cannot be the case. Yes, basic structure has been defined. It has been defined as those identity marks and immutable principles of the Constitution, such that if you change those identity marks or immutable principles of the Constitution, it will amount to the Constitution losing its identity. That is how basic structure has been defined. So it has been defined in that manner. Now, the contents of basic structure are obviously subject to debate because Constitution is a political document. You cannot have a mathematical precision when it comes to interpreting law, and that is not something which should be expected out of law. So we need to come out of that mold, that idea that law has to be so precise and has to be as scientific as maybe a mathematical formula. That is not possible. But with regard to why it has been defined, basic structure has been defined. It's just that it is fluid in nature. It is not defined exactly to its contents because you need to allow basic structure doctrine and any provision of law to have scope to evolve. Otherwise, it becomes rigid. And in order to avoid that rigidity, while the idea of basic structure has been defined, the content of the basic structure have not yet been codified, because such kind of codification would in a manner prevent the basic structure doctrine from evolving. So while I disagree with you on the count that basic structure has not been defined, and I acknowledge the fact that yes, it has not, the contents have not been codified per se or have not been strictly restricted, but I don't think that is required because otherwise it will not allow this doctrine to have a life of its own, and that is something that must be allowed to any legal provision. Can Parliament define basic structure? Tomorrow it may pass a law saying that, but more or less basic structure doctrine is the power of the judiciary to determine what is the basic structure. Now, the reason why, as I told you, the reason why basic structure doctrine came into being was precisely because the final arbiter of the constitution became the judiciary. If parliament defines basic structure, the entire logic or the rationale behind basic structure goes away. Because then it would amount to parliament determining what the constitution is about. And that is something which the judiciary very clearly said. And that law made by the parliament defining basic structure would again be subject to judicial review. So even if parliament tomorrow defines basic structure, it would be subject to judicial review of the judiciary. And that would in a sense mean that it is the judiciary who is defining basic structure or who is determining the scope of basic structure. So for all practical reasons, no, parliament cannot define what basic structure is. They make an attempt, but it would be KESHWANAND, BHARTI and Mishra, or was it the other section? Did I discuss KESHWANAND, BHARTI from the case material in this class, or was it the other section? Can anyone remind me?
No, ma'am, we discussed Golaknath case.
Okay, fine. So, what we'll do today is we will discuss KESHWANAND, BHARTI as well as I think if we discussed Golaknath, I must have discussed KESHWANAND, BHARTI. Anyway, we will just discuss KESHWANAND, BHARTI and then also IR Coelho judgment, which is another basic structure, case on basic structure, which is a part of your unit 1. Now, just to briefly summarize what we discussed last time. So, in the last 2 classes. So, what we have discussed is that basic structure doctrine and the reason why basic structure doctrine came into being. And we also discussed how Golaknath judgment interpreted basic structure doctrine, right? So, if you remember, basic structure doctrine was interpreted in Golaknath judgment. And was actually basic structure doctrine was not brought in Golaknath judgment. Rather, what was said in Golaknath judgment that there are certain limitations on the power of the parliament to amend the constitution. Now, how were those limitations read as a part of the constitution? What Golaknath judgment said was that constitutional amendments are law under Article 13 of the constitution. Now, if you look at Article 13 and specifically Article 13(3)(a) of the constitution, it defines law. And it says that law includes, and I hope you have a BEAR Act in front of you, and if you could just open it to Article 13, Clause 3, Subclause A. What does Article 13(3)(a) say? It defines law, and it mentions that in this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India the force of law. So that is how law has been defined under Article 13(3)(a). Now, what Golaknath judgment did was, if you remember, I told you in the very beginning when we were discussing a brief discussion on Part 3 of the Constitution, that if you have to prove that there are 2 ways of challenging something for violating fundamental rights. The first is that you will have to prove that the violating entity is a state, okay? Because primarily, Part 3 of the Constitution is vertically arranged. That means that not all, I am not saying all provisions of Part 3 of the Constitution. So, that is something those are the 2 important provisions that you need to understand before you even go into the question of whether there is any violation of fundamental right or not. First, that you will have to prove that the violating entity is the state. And in case you are arguing that a legislative enactment violates fundamental right, then you will have to prove that that specific law is a law under Article 13(3)(a). Now, you already have studied about one form of law which has not been considered to be a part of Article 13(3)(a). Any idea which law is not a part of Article 13(3)(a)? And you have already studied it as a full-fledged course.
Law in 9th schedule.
Okay, not exactly, and this is something that we will come to when we are discussing IR Coelho. Yes, Sagar, personal laws and amendments. So, I'm not going to say amendments right now because we are still having a discussion on amendments. Yes, very correctly said, personal laws. Remember your family law lectures, there must have been a discussion on whether why are personal laws not challenged for violating fundamental right, because there are so many aspects of fundamental personal laws which are on the face of it discriminatory. And you must have studied those aspects. For example, if you look at Hindu Succession Act, the manner in which property is distributed vis-a-vis married woman and a male. Now, married female's property, the first, primarily it goes to the husband's family, and only when even the agnates and cognates of the husband's family are not there would it revert to the woman's parents. On the other hand, that is not the case with the succession of property when it comes to a male. And even in other, so there are several instances of discriminatory laws when it comes to personal laws. But why are personal laws not challenged for violating fundamental rights? Not that they're not challenged, but why have they not been declared unconstitutional? Because if you remember Shaira Bano judgment, and I'm sure you must have read Shaira Bano judgment in your family law, there is something called Narasu Appa Mali case wherein it was said that personal law is not a law under Article 13. Now, I'm not going into the details of that. If you want to read further on how Narasu Appa Mali case unfolded and what is this interlink between Article 13(3)(a) and personal law, maybe you can look at three pieces of literature or judgments. One is Narasu Appa Mali, obviously, which is a Bombay High Court decision. The second is Justice Nariman's opinion in Shaira Bano judgment, which is a triple talaq judgment. And the third is Justice Chandrachud's opinion in Indian Young Lawyer Association case, which is the Sabrimala entry temple case. So these are the three opinions. If you read, you will have a fair idea of how personal laws are placed under Article 13(3)(a). But yes, Sagar, so I'm not going into the detail of personal laws. Yes, but personal laws have not been categorically considered to be a part of Article 13(3)(a). Now, it is not that easy because obviously certain changes have happened, specifically when you read Shaira Bano judgment and Nariman's opinion. But for the time being, you can understand more or less personal laws are not considered to be a part of Article 13(3)(a), and therefore they are not challenged they cannot be per se challenged for violating fundamental right. Now, the second is amendments, yes. But before we come to amendments, let's first understand Golaknath judgment. What Golaknath judgment said was that amendments are law under Article 13(3)(a). Constitutional amendments are law under Article 13(3)(a). And because constitutional amendments are law under Article 13(3)(a), anything that is a law under Article 13(3)(a), what can be done? It can be challenged for violating fundamental right. So because constitutional amendments are law under Article 13(3)(a), they can be challenged for violating fundamental right. Now, the reason why Golaknath judgment said is, and I think we discussed this in our last lecture, was because Golaknath judgment argued or held in its majority decision that the power to amend the Constitution is found in the same provision where you find ordinary legislative power of the Parliament. That is Article 245 to 248. So the ordinary legislative power of the Parliament, what is ordinary legislative power? And we already drew a distinction between ordinary legislative power and constituent power. Ordinary legislative power is the power of the Parliament to bring about simple enactment, which does not involve amendment of the Constitution under Article 368. Now, the ordinary legislative power of the Parliament and the constituent power of the Parliament, both are vested in the Parliament by virtue of the same provisions, that is Article 245, 246, 247 and 248. And because both of them, it is the same provision that vest on the Parliament both the ordinary legislative power and the constituent power, therefore we cannot put them into any sort of hierarchy such that ordinary legislative power is subject to being challenged for violating fundamental right, but an exercise of constituent power cannot be challenged for violating fundamental right. I hope you understood I.C. Golaknath's rationale as to why amendments were considered to be law under Article 13(3)(a). If you have not understood, just let me know. Because the reason being that it was held by the court that the Parliament derives the power to exercise its ordinary legislative power as well as to exercise its constituent power from the same provisions of the Constitution, and that is Article 245 to 248. The power to exercise constituent power has not been vested on the Parliament under Article 368 of the Constitution. That is one of the reasons, and therefore, as a consequence, what Golaknath judgment said was that therefore, Article 13(3)(a) in the term law includes constitutional amendment. Now, as soon as you say that the term law includes constitutional amendment.
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें। थैंक्स फॉर वॉचिंग।